this is the first program I'm able to get up is Zoom. So I'm still waiting on Odyssey and actually some other things to come back up. So it felt like that kind of Wednesday. So I hope everybody's all right. Good morning. This is Judge Alyssa Perez presiding over the 210th District Court civil docket for August 16, 2023. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for viewing. Mr. Marufo, would you call our next case, please?
Second on page 1, Judge. In cause number 2023, DCV 1997, Edna Torres et al. Versus Nadia A. Galaz Carrion. Announcement of counsel, please.
Good morning, Your Honor. Thomas Carter for the plaintiffs.
Morning. We have this down for a motion hearing, Mr. Carter. I'm going to ask you to proceed. Odyssey is loading up very slowly for me.
Yes, Judge. We've attempted to effect personal service on the defendants. We've been unable to do so. We filed a motion with an affidavit of due diligence, and we'd just like to be approved for substituted service, Judge.
Okay. Myrna, did we receive this? Did I ask that it get set for a hearing?
You did, Judge.
I'm sorry, I did. Let me look at Mr. Carter. There usually I don't set these for hearings, so let me look and see if I had a concern.
I have a question, Your Honor.
Is that Mr. Forbes?
Yes.
Yes, sir. Are you on this case?
Yes, I don't understand why he can't serve everybody through Rule 21A. Why he needs to have personal service on the defendants. All the attorneys are in the case already. Pursuant to 21A, if he serves the document on the attorneys, that's sufficient service.
Mr. Carter, have you served it? My Odyssey is still loading, so
I didn't know if Mr. Forbes was involved in this case. Are we on this?
Are we talking about Edna Torres and Emerald Diaz, Mr. Forbes?
Oh, I'm sorry. I'm on the wrong case.
Okay.
I just thought I'd help out the court.
I told you it's something about this.
I apologize, Mr. Carter. That's fine.
No worries, Mr. Forbes. I appreciate you.
Okay, it's loaded up now.
Thank you.
I'm just excited to being
Mr.
about being in court.
I have not had any coffee today, so
No.
you're gonna throw me for a loop pretty easy. Okay, it's
This
loaded
is
up
my
now.
first cup. This is my first cup.
It's loaded up now. I'm trying to see, and of course my email is not loaded up yet. Give me 1 second.
Thank you. Does it have our motion in here and stuff?
All right. Yeah, I'm not quite sure why I requested this for hearing. In any event, Mr. Carter, that is going to be granted. I do have your proposed order, and so I will sign off on that today and get it filed with the papers of the court, okay?
Thank you, Your Honor.
My apologies for the delay.
No worries, Judge. It's always a pleasure. Thank you.
All righty. Thank you very much. Who's next? Thank you, Mr. Carter. You're excused.
Continuing on page 1, Judge. In cause number 2022, DCV 0396, Cecilia Moreno versus Ariana Murillo. Announcement of counsel, please.
Scott Brooks here, Your Honor, on behalf of the plaintiff, Cecilia Moreno.
Good morning.
Good morning, Matsuri Camacho on behalf of the defendant, Ariana Murillo.
Okay, and we're set for scheduling status conference. You all ready for a trial date in 2024?
Yes, Your Honor.
Give me 1 second. Okay, so let's do August 2nd, 2024. Let me look at this. Looked like you had a scheduling order, substitution, and a transfer. Okay. I was just trying to look at the events in the 448th, but if you all are good with that timetable, what we will do is based on that trial date, you'll have a docket call on the Wednesday before that trial date. 30 days before that, you will have a final status conference. Your mediation deadline is the Tuesday before that final status conference. So if you'll fill out the court scheduling order, come to an agreement regarding your mediator and return it to the court, we'll have a hearing in 2 weeks for entry of that scheduling order. If you have it turned in, then you don't need to appear. Okay.
Okay, thank you, Your Honor.
Thank you very much.
Said
Take care.
August 6th, August 2nd.
2024.
All right, thank you, Your Honor.
Thank you. Take care. Thank you, Ms. Camacho. Who's next?
Continuing on page 1, Judge. In cause number 2021 DCV 3473, Yaria Vasquez versus Gabriel Ruiz. Announcement of council, please.
Good morning, Your Honor. Gabriel Perez on behalf of the plaintiff, Yaira Vasquez.
Morning.
Good morning, Your Honor. Joe Garcia on behalf of Gabriela Ruiz, the defendant.
Okay, final status conference. Have you all mediated?
We have, Your Honor.
And we're going to trial?
It's
Correct, Judge.
Okay. Well, you're set for the 20th. We'll have our docket call on the 18th. We still have that final civil pretrial, but I expect that we may be in trial the previous week, and I'm not really sure how long that's going to take. So just heads up on that, okay? Is this our first trial setting? Yeah, it is.
It is,
Sure
Judge.
Okay, well, we'll see what happens at night on September 20th. Thank you.
Thank you, Your Honor.
Thank you, Judge.
Take care, Mr. Garcia. Who's next?
Thank you.
Top of page 2, Judge. I just need to confirm, is somebody here on behalf of Mr. Greenberg?
Yes, I'm here on behalf of Mr. Greenberg.
Okay, Judge, I believe we have everybody, Judge.
What?
In cause number 2021 DCV 3028, Rosa Maria Saucedo de Alonso et al. Versus Fifth Floor Freight LLC et al. Announcement of council, please.
This is Zach McFarland for the plaintiffs.
Norman Snyder, Your Honor, for Fifth Floor Freight LLC.
Is that Ms. Horn? Are you on this one?
Yes, Lauren Horn, Your Honor, for cross defendant Detmar Logistics Leasing LLC.
Aren't we missing a few more people? I'm
Stuart
sorry.
Forbes on behalf of Edith Erickson and Daniel Huerta.
Susan Forbes on behalf of Berta Yanez Ortiz.
Nick Pena on behalf of Claudia Guzman.
Is that everybody? Yes, okay. Alrighty, status conference today. We have our jury trial in March of 2024. Does somebody want to start, Mr. McFarland, with an update?
Yeah, so Your Honor ruled on our motion to compel Samsara data from defendant Fifth Floor Freight. And I believe, so I was not there, Mr. Greenberg was there, and I believe he went to Mr. Snyder's office and was given access to a computer, and he was logged in, and it was in order to try to access or capture any data, information, photographs, or video from this July 24th, 21 trip. My understanding is that none of that information was able to be accessed. Some of it looked like it may have been deleted, but in any event, Mr. Greenberg was not able to actually access this information.
And so are you seeking any other relief? I mean, I thought that was supposed to be, I thought it was like an online system that you were able to log into. I wasn't aware that, or I don't know that Mr. Greenberg had explained there could have been, I guess, deleted information, or have you all put in or filed any type of request after that meeting?
So I believe it is an online portal, and he was able to, my understanding is he was able to log into it, but after that point, he was not able to see anything related to this trip, is my understanding of how this went. And that's not what was supposed to happen, basically. So I am requesting further relief First, the identification by fifth floor of any fifth floor employee who has had access to this information or did access the information following the July 24th trip. Any kind of Outlook, PST, or other kind of native communication file for those individuals from following this incident that would be related to their access of it. Now, also, I would like to take a limited corporate representative deposition of fifth floor freight that would not count against the rest of our time, limited solely to the topic of document retention and data preservation. And finally, I would like to take the corporate rep depot of the non-party Samsara, where we'll learn more about how this information is stored, whether that third party still has it, and be able to get a better read from the actual the platform owner of how this information is stored and who could have accessed it and what they could have done with it.
And you've made those requests to, I guess, the respective parties, Mr. McFarland? Is that what? No, that hasn't been done yet?
No,
So
Your
when
Honor,
did- when did this, I'm sorry, Mr. Snyder, let me just start to get a little bit of a
Sure.
timetable in my head. When was the inspection? When did that occur? When did Mr. Greenberg go access that?
It was Thursday, August the 10th, Your Honor.
And Mr. Greenberg is just in trial right now. That's why I'm
Sure.
filling in for him. But I believe that's right. And Mr. Snyder, I believe he came over to your office. Is that correct?
Mhm.
That is correct, Mr. McFarland, in Your Honor.
Yes, sir.
Although I was not here, I was in the hospital last week. I had an associate who has been assisting me with the case, facilitate access to the portal. That's what the court ordered in its order of June 26, that we allow them access to the portal to determine whether or not there was any other photographic evidence or video evidence concerning this particular trip that was recoverable. As the court may recall, we had produced a couple of months ago, or more than a couple of months ago, the last snapshot image that was captured by the Samsara device that was in our tractor trailer. There was no video that was captured, and I think I explained all of that in a letter that I sent to the court and all counsel back in June. So that is in essence the only photographic or video evidence data that exists. We have not been in contact with Mr. Greenberg or Mr. McFarland concerning any of the other requests that he's made this morning. So I would respectfully request that if there are additional things or relief that they're requesting, that they put that in a letter or something to me, and I'm more than happy to respond to it.
And I was asking that, thank you, Mr. Snyder. I was asking that because I wasn't sure. I was looking through Odyssey to see if there was anything filed relative to any relief the plaintiffs were requesting on that whole data. I remember the screenshot and how there should be more, and that's why you wanted to inspect. So thank you for the heads up. I guess we can anticipate that not only will you all work on it, but I will probably have to on it later. I'm also, Mr. McFarland, I mean, so I'm, balls in y'all's court on that end to see what it is you all are going to pursue. But in looking at Odyssey, I see there's a whole bunch of things filed here. What other updates do you have for me, Mr. McFarland?
I'm not sure if there's anything else that's outstanding for today or not. My understanding was that we would be addressing the inspection, and it sounds like no one who was actually at that inspection is even here today. So but I'll turn it over to Mr. Pena. I'm not sure if there's something else that was on the table for today.
Okay, Mr. Pena, tag, you're it.
Okay. Yes, Your Honor, since our last hearing, there have been some additional parties added to this case, interrelated. And I believe we're just waiting for an order for substitute service on some of those defendants. Some of the other defendants will probably have an appearance very soon based on outside correspondence. So I can't really speak to those parties that are not in the motions for substitute service, but there could be some additional counsel. And I do believe that so many parties, the plaintiffs, Mr. Greenberg's clients have also added some additional parties as well. I've seen an answer. There's probably some more answers coming. So that's what's going on as far as this. I imagine there's going to be more. There's also some outstanding discovery that I've also sent to Ms. Horn's clients that was subsequent to a deposition that was taken. So we're still working on the case, as you can see.
Okay, so I'm going to, I'm trying to figure out which way to go because I feel like Mr. Forbes's comments on the other case earlier may have had to do with these several motions for substituted service. Mr. Forbes, I'd like to come over to you. I have not seen, so whoever's filing the motions for substituted service, if you haven't provided those via email to Ms. Hernandez so I can review them, the email is still acting up and I'm not able to access it now. So if you've done that and they're there, my apologies. But Mr. Forbes, was that what you were addressing in the other case?
Yes, it was. If there's defendants that are in the case and the lawyers are representing those defendants, there's really no need for substitute service. Just serve them by Rule 21A, if that be the case. I didn't examine the motions that close to see if there were service upon existing defendants or not. But I'm sure.
And if I may respond to that, Your Honor, and I'm sorry, Mr. Forbes, I didn't mean to cut you off.
Please do.
I wanted to say that, I think you may be referencing us because our office represents Detmar Logistics Leasing LLC. However, there are different entities that we do not have authority to accept service on behalf of. As you know, with any case, there's coverage issues. We don't make those coverage decisions. It's my understanding there has been some communications with different counsel on different parties outside of my presence. And so I have no authority to accept service on behalf of those other entities at this time.
Your Honor, this is Norm Snyder. I think Ms. Horn is correct. I know that Mr. Greenberg and his firm had recently named several new defendants. For lack of a better term, I'm going to call them corporate entities, but none of these entities that have been recently named are currently parties to the lawsuit. So I do not believe that service can simply be effectuated by giving a copy of the pleading or the amended petition to current counsel.
Got it. All right.
I'm glad I'm in the loop because I had no idea.
You and me both, Mr. Forbes. Okay, so let me go back to. So we don't come back until January officially. But I don't know why something tells me we're going to come back sooner. I'm going to need to look. So whoever, just email all of those motions. I do see the recent filings to include amended petitions, pleas and intervention, I believe, if I remember correctly. And so unless you have something to address on those specifically now, I'm fine just moving on to the final status conference. If I need to have any of these subservice motions set for hearing, I will set them. And if you're requesting that, certainly make your request when you send your pleading. Anything outside of that, I'll rely on you all to request a hearing outside of our current settings. Okay. The courts, I mean, I guess everybody's getting as busy as we are here, and just know that the court's trial will have some unavailability as September, October roll around, might lighten up in November. So just keep that in mind as we need to schedule things before January, okay? Is everybody good?
Yes, Your Honor.
Well,
Yes,
thank
Your
you
Honor.
all for appearing.
Yes, Your Honor.
Good to see everyone.
Good to
We'll
see
see you
you,
at the
Your Honor.
we'll see you at the next setting. Thank you for the updates.
Thank
Thank
you.
Your Honor.
Thank you.
Are we excused?
Thank
Yes,
you, Your Honor.
have a good day.
Thank you.
Mr. Marufo, if the parties are here I want to wait on Dodeca, so I don't know if that is Mr. Doyle. I'm not sure who you were here on.
No, that would be Mr. Castillo, Judge.
Okay, so we'll come back to that one. Is
Okay,
is
Judge.
anything else ready?
Yes, Judge. Page 4,
Mhm.
in cause number 2020 DCV 4223.
Ah.
Leticia Isabel Lawrence et al. Versus Tenet Hospital Limited et al. Announcement of council, please.
Paul Grajeda for plaintiffs, Your Honor. Good morning.
Good morning.
Cynthia Llamas here for the hospital.
Morning.
Judge Frank Doyle here for Kristen McTighe and SCP Health, Pearsall Emergency Medicine Associates.
I didn't mean to throw you on another case, Mr. Doyle. My apologies. I feel like I haven't seen you all in a while. Goodness. It can't be. Since November of last year?
It might have been, Your Honor.
Wow. Okay. Well, we're set for trial now in October. How are things going?
I was going to wait for Mr. Grajeda to.
I know. Mr. Grajeda?
You know, Your Honor,
Judge, we need to
I've been
depose
asking-
experts.
Yeah, I've been asking for plaintiff's experts since May. And I have yet to receive a single date. And I'm sure Mr. Grajeda has been, he told me at one point that he had an arbitration that was really taking up a lot of his time, but still waiting.
Well,
Yeah, Judge,
uh-huh.
I did, Ms. Llamas Craig had kind of a really long software license arbitration in April that took a week, and then they added another week in June, so that kind of took up and then post briefing in July. So I'm ready to go on getting these people lined up for dates. But I think based on our discovery deadline and the scheduling order and the trial setting and the work that I'm doing with Mr. Doyle to try to get that case resolved, I think we're probably gonna ask the court to push the trial setting back just a bit to get those depots done on the hospital side.
Ms. Llamas?
I was unaware, I was unaware that there were negotiations going on with my co-defendant, and that's neither here nor there. I am a solo practitioner now, and even if it's only us to the hospital, I'm still going to have 7 experts to depose on plaintiff's side. And they range from Michigan to California to New Mexico and Texas. So pushing it back a few months, 7 expert depositions and then my defense expert depots, it might need to go into next year. I don't think just 2-3 months is going to do it. But I agree, we can't try the case. The case is set for trial in October. Discovery deadline is next week. We're not going to reach this case.
My concern is we had a jury trial in April of 2022. We gave a huge window to move it to January of 2023. And then another almost a year to get it to October. That's a lot of time where.
Yeah, I've been asking for these depositions, Your Honor. I haven't laid on the law. I haven't sort of been stalling here. It just is what it is.
No, I'm not. It's not, on you necessarily, Ms. Llamas. I'm just not understanding why overall we're waiting until a final status conference 2 months before trial to say, oh, we still have a lot of work. I'm not hearing a lot of movement. I'm not hearing any movement actually from the last trial setting.
Yeah. The thing is, I could have filed maybe a no evidence motion for summary judgment, but I try not to do that so long as plaintiff's counsel assures me that they're working on getting dates, because it's kind of a very aggressive move. next time perhaps I will, but I wanted to extend that courtesy to Mr. Grajeda, knowing that he did tell me he had, that arbitration was really eating up his time. I chose not to do that.
Right, yeah, Judge, my September, October, November, the reason I mentioned those couple of months is they're very open. I'm sure we'll get those depots done here if we need them in the next couple of months. And assuming that, you know, we've got 2 other lawyers involved, obviously, we got to coordinate with their schedules for sure. But we can get the depots knocked out, I think, in short order, assuming everyone else's calendar is equally open.
That's not the case. That's not the case. I'm like Cynthia, Your Honor. I've got one other lawyer helping me, but an inexperienced lawyer, and I don't have a single day in August, and my September is pretty full too. So despite Mr. Grajeda's thoughts about open dates, I've got the same problem that Ms. Llanos has as far as availability. And with respect to negotiations with Mr. Grajeda, I'd say that we're hoping that we get somewhere on it, but I think there was some misunderstanding about plaintiff's damage model, and it caused a significant delay. And hopefully we've worked through those issues. And obviously, if the case can get resolved as to my client, it streamlines things quite a bit. But at this point, I guess there are no assurances that that will get done.
We did mediate the case, Your Honor. So we have made efforts to try to resolve the case.
I'm not really, and here's also part of my concern. I mean, I hear, you know, you all schedules, but, you know, I'm not inclined to move it without some agreement and firm dates of when depositions are going to happen. And then we have to look at the court's calendar. Quite frankly, my calendar is slammed with trials. This is whatever you want to call it is happening in this building, is everything that we got to kind of move past during COVID is here. And so things are having to be tried, and you all have been given a lot of time to resolve some of these things. So what I mean by that is I'm not going to move it until you all have an agreement firm with deposition dates, agreements with respect to anything that might come from that, and then with a trial date that then I can try and accommodate.
We just need dates for all, 7 experts from plaintiffs in order to be able to do that, Your Honor. But I understand.
Exactly. I mean, there's really not been, I mean, I see it, let's see, trial witness list of defendant, designation of experts back in May. That's it. That's it since the discovery control, when the discovery order was entered. Really? I mean, we can't do that. You know, 2 months, Mr. Grajeda, being really busy that's just, I mean, I get it. Okay, you were busy, but that's just 2 months. We've been at this for a while. You need to have
Judge.
full, you all need to come to an agreement on a full slate of deposition, agreed deposition dates, all of that by September 20th.
Okay, Judge, I'll get dates over right away.
Yeah,
Thank you,
Your
Your
Honor.
Honor.
Just to let Mr. Grajeda know, I think I let the court know, and thank you so much, Your Honor, for moving this hearing to this week. I'll be out of the country. I haven't had vacation in years. I'll be out of the country for the rest of August, and I'm starting trial in September. So I will respond as soon as I can, but I'm out of the country for most of August.
All righty. Well, happy vacation, I'll say that.
Thank you. My husband wants to see Notre Dame play Navy in Dublin.
Oh, cool.
So,
Oh, that's awesome. Good for you.
yeah, I'm not big on football, but my husband loves both teams. And
oh, that's awesome. Good for you.
That's great. Let's see what you all have on September 20th. No, with whatever proposed dates, I'm thinking in terms of the trial setting, you might want to give me a window or a couple of dates, because we are already busy into 2024 with special settings. So,
Okay.
all righty, we'll see you then. Good luck.
Thank you, Judge.
Your Honor.
Have fun,
Okey
safe
doke.
travels. Take care.
Bye-bye.
Who's next? Mr.
Good.
Lo.
Good. On page 3,
Mhm.
I'm still missing Miss Susan Cooley on cause number ending in 1464. But I called them and left them, and the receptionist said that they were gonna log in, but nobody has logged in yet.
Okay, so we have Mr. Harvey and Mr. Veal. Were we missing Miss Cooley last time, or did she appear last time? Let me see. Oh, this is scheduling conference 1464.
If you'll remember, this was a case where my client, the young man, Dominic, was undergoing diagnostic treatment, and we just agreed to postpone doing anything until we got a more definitive diagnosis. I think since that time, Mr. Shell, who was lead counsel, has passed away, and Miss Cooley has stepped in. So I'm sure she is swimming upstream in a lot of cases, trying to catch up with the loss of her partner.
Okay. Hang on one second. Well, but we still need her to appear. Did she open the notice?
She filed the notice of lead counsel.
Mr. Medina, do you see notice of today's hearing to see if she opened it, or do we have a contact number? Do you, Mr. Harvey, do you have a different
Sure.
contact number than we do, maybe?
Let me open that real quick, Judge.
What was the name again, Judge?
She filed the notice of appearance on June 5, and she left a email scooley@shellcooley.com and a phone number.
Right, is that separate? I mean, have you been in touch with Miss Cooley?
I have not. I communicated with her when she lost her partner, but not since then.
And I haven't either, Your Honor. I haven't talked to Ms. Cooley since she filed the notice.
Judge, I think what we could do, if the court would indulge, is I would bet that I think we're in a position now where we can start working on the case. My client is going through diagnostic testing yesterday and today. We're probably going to get some results next week, which is going to put us in a position now to know more so we can move forward. I would anticipate counsel could put together, I've worked with all these lawyers in the past, we can put together for the court a scheduling order to get this case set for trial sometime, my guess, after hearing what you've been talking about, later next year, maybe, and get something in front of the court relatively soon, I would anticipate.
Okay, so, and that's fine. I don't, it's a scheduling status conference. If you all are telling me we're ready to have a trial date set, yes. Are you telling me 1 year is okay, or is it complex, or you need more than that time?
Well, it is complex, but I would think, you're not going to be setting this case until the end of next year, right?
No, I'm looking at August of next year. I go 1 year out, and this one, it's filed already back. We had you at a.
I think next year, August next year will work for us. We're going to have, we're all experienced in these kind of cases, so I bet we can do that.
Okay, so I'm going to
Mr.
set it.
Valier?
Yeah, it's Veal, but that's all right.
Veal, that's what I meant to say, sorry.
Yeah, that's okay. I grew up in El Paso. Everyone always pronounced it Valle, but it's just Veal.
Valle.
Or Ville.
Oh, wow.
Yeah.
Okay.
You can call me Harvey if you want.
It's a weird Wednesday. I'm looking at August 16, 2024. Mr. Medina, what I was mentioning is if Miss Susan Cooley opened the notice hearing notice for today.
Judge, what's strange is her name isn't even on the details to see if she opened it or not.
Oh, well, there we go. So she filed, let's see, that notice of appearance on June 5th. So I'm not sure. why that's not there, but that will certainly explain why she's not here. So with that date, I'm comfortable circulating. Mr. Medina, we need to update her as counsel for one of the defendants or some of the defendants. And then circulate the scheduling order amongst counsel with that trial date. I don't imagine the scheduling status conference is such a big deal that we can't just go from here with that date, have our docket call, know that you all have to agree to a mediator and include it on the scheduling order and return it to the court in 2 weeks. If there's a problem, we'll have our setting in 2 weeks so that you all can tell me why this is not a good scheduling order. But if you all will just agree to that along with Ms. Cooley and return it to the court, I'm satisfied with that.
Judge, on the scheduling order that the court sends out, if we agree to a different date, like on designation of experts or stuff like that, do we need to have a hearing or we just submit it with our agreed date subject to the trial date that you've identified?
No, if it's agreed, just include it on there. That's the whole idea, that each of you all are in agreement, sign off on it, send it back to the court and I'll sign it.
Good deal.
Okay. All right. All righty. Well, hopefully we can get this notice issue figured out and we'll.
When I get it, I'll forward it on to Susan as well to make sure she sees it.
Thank you very much.
Thank you, Judge.
Y'all are excused. Thank you, Mr. Beal.
Thank
Bye,
you.
Mr.
I'll see you later this afternoon, Your Honor.
This afternoon for
I
what?
think we have another hearing, another scheduling order hearing, I think, with the
Did it not get turned?
with Mr. Melendez.
Okay. All righty.
We're working on it. Maybe I won't see you.
Yeah, nobody shows up for the 3 o'clocks. I just kind of ignore those because they're automatic. All right. Take care.
Thank you. Bye.
All right. I see Miss Castle. Is someone here on that case aside from Miss Castle?
Judge, I called Martinez, Mullen and Abbey Lane and no answer. Tried them twice at their office, Judge.
It's the city, right? Am I not? Oh, wow. Well, let me just ask Miss Castle, I think we just needed to close this out.
Well, and so I really honestly, in all honesty, Your Honor, I apologize. I'm in the middle of a mediation. The associate assigned to this file is no longer with the firm. Ms. Verghese is a relatively new associate to the firm. And the paralegal and I and Ms. Verghese are trying to figure out the actual procedural history. It looks like the city filed an appeal of this court's ruling. And it looks like the city also requested that the appeal court's record be corrected. And it was denied. And the last person we spoke with at the city was Carla Neiman. I think she's the one that filed the last live pleading that we can find. And so if the court would indulge us, we would like to have this hearing reset so that we can make every effort to contact the city and see what their position is. This was a hotly contested case where our client was working.
I remember it. I remember it. And it was one that actually we picked up after we did a search and had not picked up the mandate from the Court of Appeals. So that's why we had it set, kind of quickly. I don't have an issue if we need a reset. I'm surprised the city isn't here though.
As am I, but I think it might be the same issue that sometimes we have at my office is maybe a change in staff. And maybe just, it seems like everyone's kind of dealing with water hose type issues, trying to get caught up from the pandemic. That's not an excuse, Your Honor, but I will make every effort to discuss this with the council of the city and give the court an update.
All right, reset for 30 days. Thank you very much.
Thank you, Your Honor. And thank you to whoever called us to remind us to get on the hearing. We appreciate it.
Thank you. Who's next?
Top of page 5, Judge. In cause number 2022, DCV 3622, Mary Gonzalez versus Covencio Pacheco and Rebecca Pacheco. Announcement of council, please.
Good morning, Judge. Nasim Saloom on behalf of Mary Gonzalez.
Good morning.
Good morning, Your Honor. Enrique Lopez on behalf of Covencio and Rebecca Pacheco, defendants.
We're set for a status. How are we doing? What are we doing?
We just need a final hearing, Judge, the trial date.
Are you all asking for a bench trial or a jury trial?
It's up to Mr. Nasim.
Judge, I believe, initially, we requested a jury trial, but that, that may change, Judge. We conducted some discovery, we've taken one deposition. I need to take the defendant's deposition. We haven't conducted written discovery. So we are progressing on that, Judge.
We've never, and, okay, so let's see, order for referral to mediation. That was back in May, but we've never had a scheduling order, right?
That's correct.
Yeah. Okay, so how about, this is gonna be your scheduling order hearing. I'm thinking, do you need more than 9 months? Do you need a year? No, you can do it in 9 months for whatever discovery might be needed before trial?
Judge, that should be fine. That should be okay.
9 months should be okay?
Yeah, Judge, 9 months
Okay.
shouldn't be okay, good.
Oh, that still gets you all the way to May, is that right? Wow. Okay. So we'll do May 10th. Myrna, do we have anything specially set on May 10th?
Checking, Judge.
Thank you. And then that would mean a May 8th docket call.
Judge, we do. The court has a civil case.
Okay, that takes care of that. I'm gonna bump it up a little bit. How about we go to, how about April 26th?
I'm good, April
That's open,
26th,
Judge.
Your Honor.
Okay, let's do April 26th, Mr. Salum.
I think that should work, Judge.
Okay. Okay, April 26th, and then that will mean an April 24th docket call. All of the deadlines are there to include a mediation deadline, which is 1 day before the final civil pretrial. So as long as you all agree to everything on the scheduling order, sign it, return it to the court, then we won't see you in 2 weeks when we have our entry of scheduling order hearing. Please include your mediator. Did you already go to mediation?
No, ma'am.
No? Had you all agreed to a mediator already?
I don't believe so, Judge.
Okay, I'm just wondering here, let me go look, why we had an order of referral to mediation via Speasney by 7/17. You all were supposed to mediate it by the 17th of July. Am I looking at the right case? Yes. Why didn't that happen?
Judge, I apologize. I'm looking through my file. I don't have the order.
The order was filed on May 18th, and I believe that was post a hearing that we had where you all were asking to be ordered to mediation. So why didn't it happen?
I apologize on behalf of the plaintiff, Judge. I don't have an answer for the court, but I know that my client would be willing to mediate, per the court's order as soon as practical.
Well, you're ordered to, that means you have to.
Yes, ma'am.
And you all both just disregarded that order.
I apologize, Judge. And we'll go ahead and schedule a mediation as soon as practical. I'm confident.
Ms. Myrna, please get me another order. Mediate this case in 60 days. I mean, I thought that was where the posture that you all took. What's the point of asking to be ordered to mediation if you're just gonna ignore it? Please circulate the scheduling order, and Myrna, please get me another order referring them to mediation within 60 days. Thank you very much. Is there anything else?
Nothing from the plaintiff, Your Honor.
You all are excused.
Thank you, Your Honor.
Thank you.
Who's next?
Bottom of page 2, Judge. In cause number 2009-2071, Dodeca LLC versus Raimundo Aguilar. Announcement of council, please.
Christopher Castillo here on behalf of the plaintiff, Your Honor, the Dodeca LLC.
Mr. Castillo, I vaguely remember there was something that we were here on last time. I think the order was already entered, something along those lines.
Yeah, and after some investigation, Judge, I guess I got a brief, synopsis of what happened. We're actually here on our application for writ askari facias. We're attempting to revive a judgment. How we filed our original application back, I believe, in 2022. However, subsequently, an order granting our application was signed prior to the actual writ being issued, so we could serve the defendant and, give a proper notice that we're attempting to revive this judgment. That writ was finally issued after an order was, that writ was issued in May of this year. And
Okay.
it was, yeah.
Okay, so we need to redo the order, basically.
Basically, the writ was issued, he was served with the hearing, with the writ, given notice of the hearing via first class mail. He didn't appear at the last hearing. I know I believe your office sent notice also first class mail of this hearing, because it was reset. So we're just asking for the judgment to be revived for that order that was signed previously.
So let me ask, I hear you. Have we had any contact from Raimundo Aguilar?
No, and I believe your honor asked the same question at the last hearing. Back then, I did explain that we did need to make attempts. Attempts were made, and as to my understanding, he hasn't contacted us.
So for my staff, have we received any contact from Mr. Aguilar? Is he here in person? Has he logged into Zoom?
No, Judge, I haven't received any communication from Mr. Aguilar.
Mr. Hernandez? Okay. All right. Then your request is going to be granted. Please send over the conforming order.
Yes, Judge.
Ms. Hernandez, and we'll get that filed. Thank you very much.
Thank you, Judge. May I be excused?
You may.
Thank you.
All right.